Thank you for joining us today for Reducing Property Management Risks in a COVID World. I'm Laura Prowse with CRES Insurance Services. Today, we welcome attorney Mark Carlson from the Carlson Law Group. Mark has been defending real estate professionals since 1993 and has worked with CRES for over 20 years as a founding member of our legal panel. Along with Mark, we have Dave Miller, Regional Vice President with Fidelity Home Warranty. Dave manages the CRES Advantage Home Warranty Plan, which ties in with CRES's E&O insurance. We have a lot to cover, so let's get started. Dave, I'll hand it off to you.
Thank you, Laura. And we're excited to be doing episode number 2. Episode number 1 was received very well on all the COVID forums, and we were very proud to educate everybody on that. Today, we're going to get into a little bit of property management because it seems to be a hot topic. So hopefully you guys get some great information out of this. Mark, in the past, there seems to have been fewer lawsuits arising out of property management. Now it's one of the leading E&O claims. And even some of the E&O carriers have stopped offering this coverage because of the claims history. What has changed all of a sudden in property management, and why has it gotten so dangerous in California?
Well, I think that there's a couple of things to look at. Firstly, in the past, there was a period when we had an awful lot of frequency in property management claims, and that's when we had the peak of the short sales and REOs in the 2009 to 2012 time period, where listing agents were having to try to maintain properties as the banks were trying to get people out. And so we had a lot of activity back in that time period. But I think what's making this time period be more dangerous, that the claims seem to be the value of the claims seem to be higher than they were back then. Back then it was just the ordinary, you wrongfully evicted me and I incurred had to go to another rental and that cost me more money, whatever they were more generic eviction type of lawsuits. Now we're starting to see, more habitability claims. And I think that is stemming from a couple of different things. Firstly, more local governments and cities are enacting their own rent control and tenant protection ordinances. And so every one of those ordinances that are passed seems to have its own attorney's fee provision. So now the value of the claim goes up because there's ability to recover attorney's fees, and that motivates the plaintiff's bar on trying to take those claims when really there may not be any actual damages, but there's a technical violation, of one of those ordinances, and then now the lawsuit is filed just so that the attorney can recover attorney's fees, and then they're just not letting them go because they know that at some point they're going to be successful on the lawsuit, and so meanwhile they're just churning their fees, and it's makes it much harder to settle those kind of cases. So I think that the value of those or the exposure is going up, and that's what's causing insurance companies to not want to write property management. And so it's also an important point now more than ever that if an agent is taking a property management client, you have to make sure that you're named as an additional insured on the owner's policy, because there are a lot of the coverages between a homeowner's policy and an E&O policy are completely different. And so if there's personal injury, or if there's any kind of bodily injury, again, personal injury or damages that are multipliers, a lot of times those kind of damages will be covered under an owner's policy that aren't going to be covered under an E&O policy. So with that, you've got to make sure that as an agent, make sure that you have in your property management agreement the obligation for the owner to name you as additional insured, and then get proof of that to make sure that actually happens. Because a lot of times that provision will be in a lease, but nobody will pay any attention to make sure that it happens. Or if you have a long-time property management client, you just forget to ask, every year, which you have to do in order to protect yourself.
Right. So do you recommend redoing those contracts each year, even if they do have a long-term contract, so that you can put that wordage in there?
The contract doesn't necessarily need to be redone. You know, you don't have to
Okay.
sign a new property management agreement with your owner every year, but you should have a tickler that allows you to, or that reminds you on every house that you have, or door as they call it, that you you contact the owner and ask, okay, you just renewed, and let me see the proof that you've named me as additional insured.
Gotcha. Gotcha. Now, of course, we're in a COVID world, so I have a COVID question for you. How has COVID affected property management, and how has it affected obtaining access to a tenant-occupied unit?
Well, so now we have another layer of the best practices that we talked about at length in the last video. So that, you know, the Cal OSHA and the Department of Health for the state of California have issued some guidelines as to how a property can be shown or accessed. It applies both. So now you've got to make provisions for PPE. You have to be mindful of how many people are in a property. You have to clean up afterwards. So all those things, and I don't want to bog this presentation down with going over all those things, but that has to all be done, you know, in relative to a landlord tenant or either regaining access to a property after a tenancy terminates, or in trying to get access to either show it in anticipation of a sale or a new tenant or to make repairs. So anytime you go in now, you've got to be mindful of the best practices.
Got it. And then also, how has it complicated the decision whether to evict a renter? If you can cap on that for a few seconds, and then explain the importance of using an attorney to do this versus just the property manager or the owner doing it, because I think there's been a lot of hot claims in that area.
Yeah, so it's I think you got to first start and look at the economics of being a property manager, right? The margins are thin. Your monthly income per house is not a lot. Successful property managers have to have a lot of doors and have to be efficient in order to be profitable. So property managers will tend to do things on their own so that they don't have to incur additional cost or spend the time going to their landlord or owner to get money to do something or to get an attorney to be hired. And I get all that, but this is the time period when you really have to be more careful and not try to just be, do everything on your own because the risks are much greater. Firstly, you've got, the risks of violating some sort of eviction moratorium or rent control protection of local ordinance, right? And they're changing all the time. So here we are, August 27, and I could tell you what all the moratoriums are and what the restrictions are based on every city and every county, but 4 days from now it could be completely different. And so, and I've been trying to, for other industry groups, trying to keep on top of these things, but they're just changing all the time. Even if you go to the CAR has a very nice list of the protections and ordinances per city and per county, and it's constantly being updated. As soon as they get done, it's like painting the Golden Gate Bridge. As soon as you get done with that list, you got to go back and start doing it over again because things have changed again. And so it just is outside, the bandwidth. Not that most property managers don't have the ability to do it, but again, it just is very hard to keep up with every single county and every single city that you might have houses in. And so when you're making the decision as to whether to evict somebody or whether you can evict somebody, that decision has to be made on a case-by-case basis at that particular slice in time. And so getting an attorney involved to make the decision as to whether there can be an eviction certainly needs to or should be made. You should get an attorney to help you or help a property manager and owner to make that decision as to whether it's legally allowable. Even in contacting a tenant has been regulated now in a lot of these emergency COVID renter protection ordinances. There's restrictions on what you can ask for and what you can say and what you can't say. So even the decision as to, okay, I need to get a tenant out for whatever reason, you need to figure out, you need to determine at that particular point in time what you can do and what you can't do and what you can say and what you can't say. And then, there's also a question of just economics. do I really want to evict this tenant? So if I have a tenant that hasn't been paying rent since March, and now it comes, let's say September 1, and there's all the rent, or or September 30th, all the, which currently, at least in the Southern California area and most Bay Area counties, September 30th is the deadline, or is when the eviction moratoriums are set to expire if they don't get renewed. So now here, let's pretend that they don't get renewed, and I'm October 1, and I need to make a decision to evict somebody because they haven't paid March or rent since March. Well, now you've got to decide from a practical perspective. Well, if I keep them in there, will they pay back some of that past due rents? If I evict them, almost certainly you're never going to see that money again. And so it becomes a business decision as to whether you want to try to hope that they'll pay some of that past due back, or whether you just want to pull the Band-Aid off quickly and get a new tenant in there and hope that, you know, the payment stream is a little bit better. And then there's, of course, there's a question that I don't think anybody can answer, whether it's an attorney, you know, or property manager, is if we have these eviction moratoriums and and renter protection ordinances that give tenants a period of time in which to pay rent back that wasn't paid in a COVID time, can you use the outstanding rent or rent due as a grounds for evicting somebody? In other words, if there's an ordinance that gives you a time period to pay back your rent, can you even evict them? Is that even a breach of the lease if they take advantage of that time period? If a tenant takes advantage of that time period in which to pay back the rent, like in Los Angeles, I think it's going to be up to a year that you have to pay back the rent that you hadn't paid during the COVID period. So it's going to be very complicated as to you know, who can be evicted and when they can be evicted, and you for sure need an attorney to help you out with that.
Right. Now, there's a lot of real estate professionals that do a little bit of property management and some that just do real estate residential sales. So for those folks, what should they be aware of when they're either listing a property that has renters in it, or they're showing a property that has renters in it? What are some things, some basic things that they should be aware of?
Well, so this gets into the category of what I call property manager by accident. Or the accidental property manager. So I get a listing, let's say from a bank on an REO, or I get a listing on a property that where there's a tenant that's occupied, and the landlord is looking forward to the end of the lease and just wants to try to get the house and, you know, marketed and in better shape so that it shows well. So now the listing agent goes and makes contact with the tenants. There's no property management agreement. They're not collecting rent. They're not doing anything. But then they start interfacing with the tenant, and the tenant starts saying, well, I've got this problem. You know, the heater hasn't worked in 2 years, or, you know, this back gate doesn't work. And now you can become an accidental property manager. If you say as a listing agent, well, I'll go talk to the owner about that. I've had a number of lawsuits where there was no actual property management relationship, and the listing agent got sued as a manager of the owner nonetheless, because these these renter protection ordinances are very, very broad.
So Mark, what should real estate professionals know when they're listing or even showing a property that has renters in it? Because there's a lot of, we talk about real estate professionals that get to be property managers by accident. And so can you touch on that for us?
Yeah, so I've been referring to this sort of humorously as the accidental property manager for years, you know, especially back like in the REO days and the short sale days, where a listing agent would get either a listing from a bank or from an owner that was, you know, prospectively trying to rent the property after a tenancy ends. And then the listing agent goes and makes contact with the tenants, and then the tenants start relaying complaints. You know, hey, the heater hasn't worked for a year. This gate to the side yard doesn't work. You know, whatever the case may be. And then the listing agent says, well, let me go talk to the owner about that. And then the tenant, when they file a habitability claim, includes the listing agent as a manager, you know, or as an agent of the owner. And we've had a number of cases like that over the years where The listing agent did nothing more than just try to secure the property, and then gets hooked into a habitability lawsuit, naming where the tenant is making claims against the owner for problems with the property. And so, an agent needs to be very careful in making it clear to the tenant in that circumstance that they're just there to list the property. And if there's any kind of friction, then it's best just for the listing agent to leave and then tell the owner, hey, when you get that property vacated, then I'll come and look at it and help you get it, prepped, ready for sale. And I'll give you a quick war story on this. So the rent control or renter protection ordinances, almost all of them have language that says there are certain things that you cannot do that would constitute a violation. But then within that, there's another clause at the end that says, and you can't assist anybody in doing a prohibited act either. Otherwise, you're violating the statute. And so we had a case not too long ago where an owner had passed and the property was held in a will, so it had to go to probate. The owner had let a friend live in a unit, back unit on the property for years and years without any kind of rent being collected. Just the guy was down on his luck and the owner was trying to be nice to him. So the probate attorney made an arrangement with the back occupants to leave so that they could sell the property. And then he hired our clients to list the property and get it approved through the probate sale. So the lawyer reached an agreement with the occupant. The lawyer prepared a written agreement and then asked our client, hey, I know you're going to go over there to go, start getting ready to be listed. Can you take this agreement to the occupant so that he can sign it and get it back to me? And so that was the only contact. There was no dispute. That was the only contact that our client had. And then, of course, once he gets off the property, the occupant talked to an attorney. There was a violation of that particular renter protection ordinance. And we were brought in on that lawsuit, or our client was brought in on that lawsuit because the act of delivering the letter was assisting within the definition of that particular ordinance. And of course, the heirs to the estate they spent the money as soon as it got released, so they didn't have money to pay for the violation that their attorney had conducted or had done. So we ended up paying a fair amount of money to try to get out of that lawsuit by delivering a letter.
We've heard about this a lot in my industry at Fidelity National Home Warranty. And when talking to Laura, she had mentioned that she's seeing an uptick of risk management calls from property managers about tenants not letting technicians into the home to make repairs. And how does that work with the owners, trying to uphold their lease agreement, but tenants just being really a pain?
Field calls off of a few risk management hotlines, CRES, of course, being one of them. And we receive calls like this frequently where the property manager will say, hey, we've been trying to get into a unit and the tenant, is either not available or we came and they wouldn't let us in because it wasn't good for them at that point in time, or now they're worried about COVID and, what do we do? And it's the basics, of course, and you would think that we get calls from very experienced property managers, but it really is just going back to the basics. Take a look at the lease. What does the lease say? Get a copy of the lease and go with or show it to the tenant so that the tenant remembers, because most every lease has provisions that deal with getting access and the notice that's required, and it isn't really a code or a civil code section question or where you'd find the answer. The answer is almost always derived out of the lease itself. So, they just have to, the landlord or the property manager needs to go back, take a look at the lease, and then they can protect themselves and the landlord a bit better, because if they point out to the tenant, okay, the landlord has the obligation to maintain the property, and the lease provides that we can come in with no notice if there's an emergency, which is sort of how the standard or the CAR lease provides. or if it's advance notice and whatever the circumstance may be, we've given that notice. You're telling us that there's a condition that needs to be repaired, but you're not allowing us to repair. So now you've protected yourself, because even on the most tenant-friendly ordinances, correcting safety issues or damage to the property is almost always something that a landlord has a fairly wide latitude to be able to do.
And I see, yeah, go ahead.
No, I was just saying, so before, you call, pick up the phone and call a hotline, the property managers in that circumstance should go dig out the lease and see what it says.
Right. I think if it's a smaller issue like an appliance, it's probably okay. But when you have a major issue like maybe a massive plumbing leak or a water heater that really affects the owners or the renters being in the property, that's where it probably gets a little bit more tricky if they are reluctant to let anybody in. Right.
Well, it's a habitability issue for the tenant, whether the condition is also creating a habitability issue for neighboring tenants. Those are all things that need to be considered. But if there's usually if there's a safety or if there's a condition that's actively causing damage, most leases allow immediate access by the landlord. And even if you get to a property and there's water coming out the front door, like in one of those Bugs Bunny cartoons, and then you open it up and it's a big flood that comes out. You can, in most circumstances as a landlord, you can go in even if the tenant isn't there in order to create or to fix those kind of issues. But then on the flip side of that is you can't make a mountain out of a molehill. You can't say that an emergency condition exists just because you want to get a look on the inside. And we've had these kind of calls from time to time too, where they're just nervous. They get reports that there's suspicious activity by an occupant. And so they want, like, the property manager and the owner want like crazy to get in there. And so they try to fabricate, an emergency condition. So you got to be careful. You got to resist that and look at the lease and follow what the lease provides. Most every lease allows for inspection periodically without a reason, provided that adequate notice is given.
Perfect. We appreciate all your time today, Mark. Some great information on property management for those who do it and those that approach it maybe by mistake in their real estate transaction. So hopefully this information was valuable. We look forward to the next webinar series, number 3 in a couple of weeks. And Laura and Mark, thank you so much for the time.
All right. Thank you for the invite.
Very informative. And just to let the real estate professionals know who are watching, a copy of this webinar is available on the CRES Insurance homepage if you look under the Claim Prevent blog. Mark and Dave, thank you so much. Very informative as always. And I'll see you soon.
Thank you.